Hello Zimbabwe, thank you for tuning in and a warm welcome to our program Labor Matters, a platform where we discuss several labor dynamics that affect the labor industry and the nation at large. In today's episode, we are discussing termination of the employment contract, and I am Brenald Chinyowa, your host. With me in the studio today is Mr. Batanai Tuwe, who is a former magistrate and currently the director for Batanai Legal Aid Clinic. Welcome to the program, Mr. Tuwe.
Thank you, Brenald, and hello, viewers.
Well, Mr. Tuwe, before we get to the heart of our discussion for the day, let's first define what is meant by termination of the employment contract.
Yes, sir. Thank you, Brenald. Termination of an employment contract is the process wherein the relationship between an employer and an employee comes to an end. And this can be done in various ways, as I'm sure we will get into.
Okay, maybe we just get into the ways in which it can be terminated.
A relationship between an employer and an employee, Brenald, is a very tacit relationship. It is a very well-regulated relationship. When this relationship is terminated, it can be due to death, it can be due to resignation, it can be due to a period when the employee conducts himself in a manner that makes the relationship no longer effective or possible to be continued, such as acts of misconduct.
Okay, thank you so much. You mentioned an issue of regulation. You said this relationship is regulated.
Yes, very
so in Zimbabwe, what laws or what labor statutes that we have that govern or that direct termination of contract?
Indeed, Brenald, the main act is, of course, the Labor Act, Chapter 2801. And this in Section 12 gives the modus operandi, or the method of how an employment contract can be terminated. We also have some statutory instrument number 15 of 2006, which also regulates how and when an employment contract can be deemed to have been terminated.
Well, thank you so much, Advocate, for explicitly defining what termination of contract is. But my question is, what can be the reasons? I remember you mentioned the issue of death and misconduct, but from the employer side, what can be other reasons that can cause termination of employment contract?
Yes, one of the reasons which has been very topical over the past year and a half or 2 years is the termination of the employment contract on notice.
Okay.
This is where the employer, due to various reasons such as perhaps economic viability of the company, decides that he can no longer keep employing the employee.
Well, so to interject you there, but my question was,
yes,
what can be the reason for a company to say today I'm terminating this? Or for an employee to say today I am terminating this relationship?
On the part of the employer?
Yes. Yes.
Yes, the reasons can be numerous, Brenald. They can be numerous. As already mentioned, it can be economic. It can be a structural reshaping of the company. And it can also be based on poor performance by an employee.
All right. Okay. Thank you so much. I think that was so clear. Can you maybe tell us more about what is called termination of notice? I heard you mentioning something along those lines. So what is termination of the employment contract on notice?
Yes, sir. Thank you, Brenald. Termination of an employment contract on notice, Brenald, is when the employer, for reasons that I've cited, states that he can no longer continue the relationship of employing the employee. What the employer then does is he gives the employee a written notice that your services are no longer required. And in terms of our law, the Section 12 of our Labor Act at Section 4A and B regulate a termination of an employment contract on notice. And this termination stems from what we term a common law right. Okay. A common law right is a right that an employer has always had from time immemorial to sever the employment relationship upon notice.
So to interject, you say, yes. Are you saying today I can just give you a notice and you go?
The law now has changed, Brenald.
Okay.
Especially since the infamous judgment of the Zua judgment by the
Yes.
Supreme Court, which was delivered by our former Chief Justice, and that's Geoffrey Chijausiku.
Yes.
Before this judgment, the employer had a right to simply issue out a letter to his employee and say, our relationship is over, please go home. And the only requirement he had to give the employee was to give written notice of 3 months if this was a contract without an expiry date or a contract without a fixed term.
Okay, thank you so much, Advocate. But I've heard employees, they've scandalized this judgment. They said it was a scandal, like it was a nightmare to them. Why are they scandalizing if this thing really existed as a common law right?
Yes, in fact, our current Chief Justice, Honorable Luke Malava, stated that employers had perhaps temporarily forgotten that they have this common law right to dismiss an employee on notice. Upon the judgment delivered in the Zuva case, employers were suddenly awoken to the fact that they actually have the right to dismiss employees on 3 months' notice without having to pay any compensation. So the reason why employees saw it as a scandal is because in essence it was Brenald.
Okay.
It is estimated that 20,000 employees lost their jobs in the month of between July to August of 2015, soon after that judgment.
But my question to you, before we agree to scandalize it, what could have been caused the sacking of the employees? Is it really the judgment itself, or there was something behind which was triggered by the judgment?
In fact, it is, if we trace our history, go back to World War I, there was the Sarajevo incident, where in only one spark led to great turmoil.
Okay.
But there were other underlying factors that led to this war. Similarly, in the case of the Zuva judgment,
maybe we could discuss such underlying circumstances before we scandalize it. Because maybe if we look at the underlying circumstances, we might see it was a necessary evil, maybe to keep the company afloat.
Well, from an employer's perspective, indeed it was a necessary evil. Many of these companies who summarily dismissed their employees were facing serious viability issues. I'm sure you are aware that there are many companies under judicial management, under liquidation, and they are screaming that they can no longer afford to keep the bulk of their employees due to the economic conditions surrounding. The overheads are high, capital requirements are high. So for the employer, for the business to remain viable, they had to minimize their wage bill. They had been trying to minimize the wage bill via retrenchment. But our retrenchment laws and policies are rather cumbersome for the employer. So they ordinarily take long and they are expensive. So when the Zuva judgment arose, in fact, almost from nowhere, employers were more than happy to exercise their common law right to dismiss employees.
We can only sadly say it arose from nowhere, but when they realize there is that gap to make.
Yes.
Well, thank you so much. Labor Matters takes a commercial break. Don't go away. Stay tuned. Welcome back to our second segment of our program, Labor Matters. In today's episode, we are discussing termination of the employment contract. With me in the studio is Mr. Batanai Tuwe, and I am Brenald Chinyowa, your host. In the previous segment, we have discussed that there are several ways of terminating the employment contract, which include, among others, death, resignation, retrenchment, and dismissal. Well, we want to focus on what we call terminal benefits now, Mr. Tuwe. What is terminal benefits?
Yes, thank you, Brenald. Terminal benefits ordinarily are the package that is entitled to an employee after the severance or the ending of an employee and employer relationship. Brenald, ordinarily this includes money is owed to the employee for any work that he has done, and also allowances that were outstanding, and even leave days that were not taken but are the employee's entitlement by virtue of his contract of employment.
All right, so does it follow that the different types of termination of the employment contract really have got different packages?
When an employee, for example, is dismissed due to misconduct, they will be entitled to any monies for work they have actually done. However, if an employee resigns, or if the termination is by mutual consent, an employee may very well also be entitled to their terminal benefits as well as additional compensation for loss of employment.
Well, so are you trying to explain to the viewers that there's a difference between terminal benefits and compensation for loss of employment?
Indeed, Brenald. Compensation for loss of employment will usually arise after the employee has been relieved of his duties by way of a notice of 3 months that the employment contract is over. Ordinarily, if an employee is fired or dismissed from employment due to misconduct, compensation will not ordinarily accrue to that person.
Okay, all right. Thank you so much. That was so clear. Well, I've heard of gratuity. What is gratuity?
Yes, gratuity, Brenald. Ordinarily, this is a way an employer gives an employee who has had long service with that organization a percentage or an amount for his service to that company. This gratuity will be paid depending on how many years the employee has been with that organization and their contribution. And ordinarily, gratuity will be paid to an employee who has long served the organization concerned.
Okay, so let's. You are saying the terminal benefits include leave days owing, salaries owing, if any, then other allowances owing, if any, and what else? I'm trying to summarize this.
In terms of the
terminal
benefits.
Yes,
and any amounts for any work done. This is especially if the contract was one where it was a fixed term contract. For example, a contract for 1 year or specifically for 1 year period, then you are entitled to any outstanding salaries for work you have done.
So maybe I didn't get you well. Does someone fired entitled to gratuity?
Ordinarily, employers will not pay out gratuity to someone who has been dismissed from employment due to misconduct. To put it in very simple terms, gratuity is a form of an employer saying thank you to the employee for the work they have done. Ordinarily, where an employee has been dismissed due to misconduct, the gratuity will no longer be available to such an employee.
Well, I think that's so clear, Mr. Tuwe. But let's say I am an employee on a fixed term contract. Yes. All right, that's maybe I've been signing 3 months contract over and over again. Mm-hmm. Then before my contract expires, let's say I've been given a 3 months contract in January, mm-hmm. and before January even ends, then I'm terminated. Am I supposed to be compensated or entitled to anything?
If it is such a fixed contract on a short term, yes. The Labour Act at Section 12 does state that the proportion of the days that have been worked on that month will be used to calculate the terminal benefits owed and also any other ancillary allowances. For example, if you have worked for half the month, which is 15 days, or for 1.5 months, which is half the period, the proportion thereof will be used to calculate the dues that the employee is entitled to.
All right, I want to also ask that when there is gratuity, does pension schemes, like when there's a pension scheme, mm-hmm. does gratuity still apply?
Yes, that is an interesting question, Brenald. Okay. Because ordinarily all employees in Zimbabwe do contribute to the NASA pension scheme, which is compulsory for all employers and employees. However, if the company does have its own independent pension scheme, then ordinarily gratuity would not necessarily accrue to that employee if the pension scheme is better than the gratuity offered by the employer.
Well, okay, let's now look at the other method of termination of employment contract. If one has been laid off, has been retrenched, what's your views or opinions on the current provisions for the retrenchment package?
Yes, Brenald, we see with the amendment to our Labour Act by Act 5 of 2015 that the retrenchment package and the package on termination of an employment contract are now the same. This is by virtue of Section 12A of our Labour Act. So in essence, for example, an employee who has served more than 2 years at an organization is entitled to 1 month's salary for every 2 years that they have worked at the organization. And this provision applies mutatis mutandis, or exactly the same, where the employee has lost employment due to termination on notice.
Okay, maybe is it a step ahead, or is it is it a step ahead for the employees and for the employers?
Yes, it is a debatable point. There are commentators who are saying that it is fair, but the employees themselves feel shortchanged by that.
For your views and comments about this program, you can contact the executive producers on the email address and the mobile number displayed on the screen, or you can log on to www.labourmatters.co.zw for more about this program. Now Labour Matters takes a short break. Welcome back to your program Labour Matters. I am Brenald Chinyowa, your host, and with me in the studio is Mr. Batanai Tuwe, who is our special guest in our today's episode. In our previous segment, we have discussed that terminal benefits include what is due for the employee before he or she leaves the employment. Also, we have distinguished between compensation for loss of employment and terminal benefits, where our special guest, Mr. Tuwe, explicitly said that these two are different. Well, I would like to pick a point from the second segment, Mr. Tuwe, where you mentioned an issue of termination of the employment contract by way of retrenchment, where I asked you that is it a step ahead or is a step back?
Yes, thank you, Brenald. In my opinion, our labor laws are rather cumbersome in terms of retrenchment, especially to the employer. The process of approaching the retrenchment board, going through the parameters as prescribed in Section 12C of the Labour Act, make retrenchment not only expensive for the employer, but also they make the time frame to complete retrenchment a very long time frame.
Okay. Well, let me ask, what is unfair termination?
Yes, recently we've had an upsurge of cases in the Labour Court and the High Court, wherein employees are claiming that they were unfairly dismissed, especially in the light of the Zua judgment that we've mentioned before. We have had cases in the Labour Court, wherein the Labour Court has stated that those who were summarily dismissed between July and August of 2015 were actually unfairly dismissed. The High Court, in fact, has ruled that Section 18 of Act 5 of 2015, which is the Labour Amendment Act, is actually unconstitutional. And this matter is now being referred to the Constitutional Court for determination.
But to my understanding, I don't understand the unfair part of it. Because the employer acted in good faith and acted according to that current law. So was it unfair termination, or is now the courts which are now being unfair to the employer?
No, in fact, there are two scenarios that occurred, Brenald.
Okay.
After the melee of employees being dismissed summarily, the parliament had to step in to stop what they term the genocide of dismissals. And the result now was that this act came into force. And because there was already damage done and people had lost employment, the Section 18 of the Labour Act was made to apply retrospectively. Or in other words, the act came into force in August, but it applies to terminations that were done in July. So by saying that this is unconstitutional, the High Court is in fact saying that no, those employees who were dismissed without compensation, actually it was the correct way to go, and that they were not entitled to compensation because that law is not constitutional.
All right, Mr. Tuwe, let's say someone has been unfair. So I understand from our discussion that we say someone is unfairly terminated when one has been terminated inconsistent with the current laws.
Yes, that is correct.
So do we have a redress at law?
The redress at law upon termination where it is deemed to be an unfair termination is actually an issue that is still yet to be correctly defined by our courts and by legislature. The issue therein being, Brenald, that if it is indeed unfair termination, what occurred in 2015, then the employee is entitled to seek the usual remedies for unfair dismissal. This is to state that they can approach the labor court to seek reinstatement. They can also sue the employer and also seek damages in lieu of reinstatement to their positions. So those tried and tested ways of a redress upon unfair dismissals will now apply to such cases of unfair termination.
Well, thank you so much, Advocate. Maybe if you can give us your opinion on the current situation in terms of termination of employment of contract.
Yes, Brenald, the enactment of our Act 5 of 2015, which amended our labor laws, was an act that was done as a knee-jerk reaction, Brenald. Ordinarily, the International Labour Organization states that before amendments to our labor laws should be effected, there must be extensive consultation with business, with trade unions, with employers, with employees, such that a position that is equitable to all parties is arrived at. Our Labour Act was very swiftly brought into law without the usual or prescribed consultative debates having occurred. As a result, you find that there are loopholes. Ordinarily, international standards, of course, as you know, on the Convention of Termination of Employment by the Employer, which is Convention 158 of the International Labour Organization, it specifically gives room, or actually is biased towards the employee. The whole point being that what the legislature intends is that the relationship between the employer and the employee, which is a sacrosanct relationship, should not easily be terminated willy-nilly. There must be reasons given, and these reasons must be cogent. So to say that this is counterproductive perhaps would be to be favoring business over labor itself.
I don't know. This basket you are calling reasons, does it also include the interest of the employer and the employee?
Of course, the interests of the employer must be canvassed.
Well, Mr. Tu, I think we might discuss all night long here, but maybe before we call it for a day, do you have your parting words to the viewers?
Yes, sir. Thank you, Brenald. To the viewers, we are, as a nation, in the process of amending our Labour Act, and we have already produced a zero draft bill, which is an initial bill on the amendments we want to our Labour Act. And I believe that these amendments are due and they are necessary. We have a situation in this nation where our labour laws are derived from numerous statutes. We have different SI units, we have different collective bargaining agreements, we have different national employment codes. Perhaps it is time to now have a Labour Act that is all-inclusive and that makes sure that it balances interests of labour, as mentioned by Brenald, and which also ensures that business remains viable at the same time. And it is my view that after greater consultation, and if the public itself can be involved in this process, we may be able to bring out a Labour Act that is fair, just and equitable.
It's getting interesting right here in the studio that we might discuss all night long, but our clock is telling us a different story. To our viewers at home, we'd like to thank you so much for staying tuned and for being with us today. Catch us next week, same time, same channel, as we discuss retrenchment, what is it all about? Who gets what? Is it fair? And where are we heading in our current situation and our current laws in terms of retrenchment? Has the laws changed? What has changed? So join us next week. Myself, Brenald, Chinyowa, and the crew behind the scene would like to say goodbye.